Hello, everyone, and welcome to day 2 of the AFI Annual Convention. My name is Erin Jordan. I'm the Vice President of AFI, and I'm here to sort of moderate and help move things along through this speaker lineup today. We have another great day of expert speakers joining us, this time focused on importers' business practices. Today is sponsored by the Gellert Global Group, and we sincerely appreciate their support of the AFI efforts working on behalf of the food import trade. Our speakers today have all agreed to stay on after their presentation to answer your questions in person. I want to mention our first speaker today is sponsored by Markham LLP. You'll notice throughout the convention that we have QR codes attached to our sponsor logos. This is to make it easier for you to scan their QR code and be taken directly to their website for more information or contact information. You know why those are there throughout. I'd like to introduce our first speaker. Ms. Dina Epstein is of counsel to the Berkeley Heights, New Jersey and New York offices of Jackson Lewis. She regularly represents employers in federal and state courts in New Jersey and New York and administrative agencies, including the Equal Employment Opportunity Commission, the New Jersey Division on Civil Rights, the New York State Division of Human Rights, and the New York City Commission on Human Rights. Ms. Epstein counsels management clients on issues relating to hiring, termination, discipline, disability leaves, Family and Medical Leave Act, New Jersey Family Leave Act, New York and New York City paid leave laws. She's been researching the laws that will apply to the post-COVID return to the workplace and has prepared a presentation today for AFI called Employment Law in the 2021 Workplace. She'll be here live now, so I'd like to welcome Dina Epstein.
Thank you so much for that. I've lost my little screen, but I'm going to get it back. And I'm going to switch to, am I presenter now? Can you see my screen or you can't?
We can see you. You just have to share your screen.
Okay, so let me go into this and hit the little share screen. There we go. Okay. Just so everyone knows, this has been pre-recorded, so I'm going to just start at the beginning and I'll stay on at the end in case there's any questions. Thanks so much.
Good afternoon. This is Dina Epstein. I am an employment attorney with Jackson Lewis, and today we're going to be talking about employment law in a 2021 workplace, return to work in the age of COVID. So just a little bit about me. I am an up-counsel attorney in the Berkeley Heights and New York offices of Jackson Lewis. I have spent more than 2 decades now serving my client.
Sorry. I don't know what I just did. Wow.
And making sure that I partner with them in what their strategic needs are. Just a little fun fact about me, my very first was a food importer, and I continue to work for them now for more than 2 decades. We are strategically located throughout the United States with 61 locations and over 950 attorneys. So regardless of where you are located or what your employment and labor needs are, most likely we have an office or an attorney there who can assist you. Now, I wouldn't be a true attorney if I didn't have some fine print before we get started. Just as a reminder, the information that I'm providing today is for informational purposes. This PowerPoint and presentation does not constitute legal advice and does not create an attorney-client relationship with Jackson Lewis. If you want legal advice, please reach out after the presentation and feel free to contact me by email or phone. On our agenda today, we are going to look at employer considerations regarding remote workplaces, we're also going to talk about the very hot topic of employer considerations regarding vaccinations in the workplace, an employer's to-do list, and generally just a wrap-up of best practices. So let's get started. Work in the age of COVID. Well, we are all on the precipice of either returning to work or we have returned to work. So what do we know about what that looks like? Well, according to Pew Research, before COVID, 20% of our workforce worked at home. Now, during COVID, 71% of our workforce was working at home. And as recently as just last week, we know that 70% of companies plan to put some form of hybrid working model in place. So in a Harvard Business Review poll, they asked, how often do workers want to work from home? Now, nearly 32% of US employees said that they never wanted to return to the office, and this was based on a survey of 30,000 Americans conducted between May 2020 and March 2021. So in our future workplaces, we at least know that we have some segment of our population that wants to work from home for some portion of the week. On the flip side of that, though, about 21% of the survey participants said that they rarely or never wanted to work from home. Now, what should we consider when we look at a remote workplace? Well, first, let's consider why we would even want to consider a remote work option for your workplace. Well, one, we found that it is a way to retain talent. A study again shows that 39% of adults would consider quitting if a flexible work environment is not available. We also have seen that it provides a talent recruitment advantage if we are able to advertise that remote work, at least for part of the time, is an option. It allows us to broaden our talent pool and also provides for a diversity of thought because we are able to broaden beyond our immediate commuting boundaries. We also see that providing some form of a remote workplace seems to help with employee morale, productivity. It also can lead to overhead cost reductions because we don't need as many services on site. It also shows that we're being responsive to childcare responsibilities of our employees, and it may have some commuting advantages for employees, which then leads to greater productivity and greater employee morale. Now, we also find that having this return to work model can address some diversity issues. So among college graduates with young children, women want to work from home full-time almost 50% more than men. But we also see, looking at this chart, that there are a significant portion of men who are college graduates with young children who would also like to be able to work from home for some portion of the time. For 0 to 1 day a week, 36.9% of men, and for 2 to 4 days a week, 40% of men. So while it drops off more precipitously at the 5 days per week, where women about a third of the time would like to work from home, and men only about 20% of the time, we do see that there still is room for men and women with young children at home to want to continue working part of the time at home. Now, issues to consider for a remote workplace. Is a remote workplace or some form of it right for your business? Well, you need to ask yourself some questions. Do all employees need to be on site every day? And if they do, what is the business reason for an employee needing to be on site? Is there productivity issues? Is there collaboration reasons? Is it actually a physical job requirement? Some jobs just can't be done from home. Is it to foster employee morale? Is it to provide greater mentorship opportunities to people at work and career progression? Is it because new hires need to get more acclimated to the work environment and it makes more sense for them to spend more time on site? But also other things for us to consider is, do we have the physical space that would make us comfortable for COVID reasons or health and safety reasons to be on site? Also, during the pandemic, maybe you downsized your workspace, so you no longer have the ability to have as many people on site as you once did. Also, another thing to consider is by having remote work, would you be able to reduce overhead costs such as janitorial services or cafeteria and food service, because you wouldn't need those to be staffed at the same levels or provide the same level of service. We also want to consider whether, if we do have a remote workplace or some form of it, do we want to let employees pick their own work from home days? We then have to contend with managing a hybrid team. So some of that will include feelings of inclusive and exclusiveness. So for instance, for those employees that come to the office more often, is there some kind of community that's being established where people who are work from home may feel excluded from some of those opportunities? And we've also found, from a diversity standpoint, that people who work from home, there was a study that found pre-COVID that their promotion opportunities and career progression were actually diminished, somewhat the out of sight, out of mind philosophy. If we were to have a remote workplace, we would really have to address how to ensure that we didn't allow the out of sight, out of mindset to interfere with justified and legitimate business opportunities for our work from home colleagues. Also, another area that employers did not necessarily contemplate with this work from home model was, what are the tax requirements and implications if employees work outside of your given state? If there is revenue and services being provided outside of the state, it is likely that you will owe state tax in that location. Also, it's important to remember that while there are many federal employment laws, each state and many localities and municipalities also have their own employment laws. So if people are working in a different state, you may be subject to that state's laws as well. We also want to make sure that if you have employees working in other states, that you are complying with their state and local compliance laws that may deal with anything from cell phone reimbursement payments to whether you're required to pay for work for home types of equipment, chairs or desks or things of the like. Hybrid office models, just by way of example, Apple recently announced that they are going to a 3-day a week in the office, Monday, Tuesday, and Thursday, and 2 days remote, Wednesday and Friday. And this will go into effect as of September 2021. You still need manager approval for the days that you will be remote, and some teams will be on site 4 to 5 days if in-person work is required. So that's one form of a hybrid model where they, the employer, are directing which days the employees will work in the office and which they have the ability to work from home. Microsoft has made a more general statement.
Times for sure that yesterday, so June 8th, I'm sorry.
2020 took the very radical approach at the time and said employees have the option to work remotely forever. Google took some form of the above, which is 3 days a week in the office, but they're going to leave it up to each team to decide which days those are. And up to 20% of employees can telecommute permanently. Now, what are some of the challenges that we're going to face with a remote workplace? Well, there are going to be some performance management issues that are manageable, but still need to be addressed. For instance, if you have employees who are taking intermittent family and medical leave or any other type of leave that can be done on an intermittent basis, it can be difficult to monitor and will really become important for you to have a mechanism in place for employees to be able to report their time that they are taking off for FMLA reasons. Also, you need to identify a way in which to have a sense of whether your employees are fully engaged. Do they feel involved in the decisions being made? Do they feel a part of the team? These are all types of things that we've been working through during COVID, and many of you have probably come up with some great dynamic ways to keep people involved, whether it's weekly meetings where everyone is on video, whether it's regular get-togethers or trivia contests.
Speaker needs to unmute.
Dina, we're unable to hear your audio.
Where it takes a
you want me to
fraction of the time.
go
Otherwise,
back?
we would ideally like to have a situation where people clock in and then immediately get temperature checked. We also need to address confidentiality concerns about what medical information is shared by employees and with whom it is shared. And we also, moving off of our left slide, we are moving forward from this temporary remote work policy, possibly to some form of a permanent remote work policy or a hybrid form, or a full return to the workplace. So who continues to work from home and who must return? We want this to be based on objective business reasons, not random personal preferences of a manager. Now ask yourself, can you factor in performance in determining who is suitable to work at home and who should return? It should not necessarily be performance-based. It really should be driven by what that person's essential job functions are. If there is a performance issue with the employee, then address it as a performance issue. We don't want to be in a situation where it appears that we're playing favorites or making preferences, and that someone perceives those preferences being based on a discriminatory reason. We can require employees to return to the work location, but we also should consider requests for accommodation based on medical reasons, religious reasons, and any other protected type accommodation request. Again, we also don't want to assume that someone can or shouldn't return because of childcare needs, caregiving responsibilities, or because they fall under the government label of vulnerable population. based on age, disability, or pregnancy. This can lead to discrimination claims. This is why you as an employer should be making business-based decisions about why or why not people need to be coming into the offices, and be able to support that based on legitimate business needs. This may also be a great opportunity to determine whether there is a need to permanently reduce the number of employees in your workforce. Such decisions, of course, should only be supported by legitimate, non-discriminatory business reasons, including a reduction in work or maybe some kind of technology that now has reduced the number of employees that we need. But this is an opportunity for you to explore that. If you do make the decision that you're going to permanently reduce the number of employees, you will also need to take into account other employment laws, including whether a WARN notice is required depending on the number of employees being laid off. Now, when employees are coming back to work, you also want to decide whether you're going to continue to screen employees and other visitors before they enter the workplace. Are we going to continue with our temperature checks, screening questions for people returning to work after being out with an illness? Are we going to ask for return to work notes? And of course, we still want to remind and encourage employees that they should not report to work when they are sick. This is what we're going to do to prevent COVID from coming back into our workplace, because not everybody, as we're going to see, is going to be vaccinated or want to be vaccinated. So what are some of the changes we are also seeing when you're returning employees back to work? We also want to remind employees or create policies that prohibit or limit the shared use of handheld telephones, headsets, or other devices that touch or are used near an employee's face or mouth. We want to determine protocols that we're going to use for customers or with the public, including reminding people it's probably still not a good time to go back to handshakes. We also possibly want to have customer-facing signage that reminds our customers of our health and safety protocols. We may be adding plexiglass to common areas or shared spaces. And also, while the CDC has made some changes to this, you as an employer can still make decisions regarding masks in the workplace. We also, as I mentioned before, want to address procedures for common areas, including breaks and meal periods, conference rooms, loading docks, reception spaces. We want to make sure that we know if we're going to have one-way traffic in certain areas so that people limit how much they cross each other, if we're going to limit the number of people in a particular space. These are all things to think about and to implement as we return to our workplaces. You also may want to determine if it's possible and practical to have a staggered work schedule so that there are fewer people working in the same space at the same time. This also can limit the spread of COVID. Now, we're also going to be facing some back to work leave issues. What if an employee becomes ill or symptomatic? Of course, we need them to not come into the workplace, or we will be sending them home. And depending on the state that you are in, you may be required to pay them for the time that they are home. You also may face some back to work leave issues. What if an employee says, oh, I prefer to stay home and stay on unemployment because I'm making more money? At a certain point, if you have work available for an employee and they decline to return, and it is the same or similar work that they previously had, including similar hours, then you most likely are able to notify unemployment that you had work available and the employee declined the return to work. But then leave it up to unemployment as to whether this person then is no longer qualified for unemployment. That is not a decision for you as the employer. That is up to the state providing the unemployment. What if an employee requests leave because they live with an individual in a vulnerable population? If the leave is because the person at home is ill, that's something that could be covered by FMLA if the employee meets the requirements of having worked 1,250 hours in the last 12 months, or there are some state family paid leave laws that could apply. But also at the same time, just because somebody has a person with who's within a vulnerable population at home, that does not automatically mean that the person is entitled to leave. Also, what if an employee requests information about another employee's health condition? You as the employer are not allowed to share other employees' health conditions. That's private and personal information. Just like during the height of the pandemic, if you had an employee who tested positive, you were not to disclose the name of the employee who tested positive, only that somebody who may have come into our workplace and may have been around particular employees, may have been exposed to somebody who tested positive. An employer's list of things to consider in determining whether to mandate versus encourage vaccines. This seems to be the hot topic of the day. So how and why does it matter if we mandate versus encourage vaccines? Well, the pros of this are employees who receive vaccinations will be able to work with much greater safety. We also know that as employee vaccine rates increase, it should promote a more stable and reliable workforce because fewer people should be coming down with COVID. Employers are also uniquely positioned to require or encourage employees to be vaccinated. And on later slides, we will talk about the incentives that the EEOC has said are available and acceptable for employers to offer to employees to be vaccinated. It may also help lead to a return to normal and progress toward herd protection. Employees may feel more comfortable returning to work if everyone is vaccinated, and customers may feel more comfortable knowing employees are vaccinated. Well, the flip side of that, though, are the cons. Right now, the vaccines are currently only approved under the emergency use authorization. Pfizer and Moderna have submitted to the FDA for full approval and full authorization for their vaccines, but that has not yet been granted by the FDA while they still look at the research. The cons also are requiring and encouraging may allow employees to blame or sue you as their employer if they have any adverse reactions to the vaccine. There also are some employee relations concerns. Employees may be opposed to the vaccine for political reasons, disability medical reasons, pregnancy and lactating concerns, religious reasons, fear of long-term unknown effects, personal security, or privacy. It also may work in both directions, as unions may use this as an organizing battle cry. In certain states, we anticipate unions will say, see, your employer doesn't care enough to require vaccinations. And then on the flip side, there may be some states where the unions say, see, your employer doesn't take into account that you don't want to be vaccinated. It's likely a no-win situation, but it is something in your particular state to consider. There's also a risk of disparate impact claims. We do have an update from the EEOC as of May 28th, in which it states employers may impose mandates or conditions with certain caveats for vaccinations. While the EEOC cannot say with any certainty that vaccination mandates will comply with other federal or state laws, it does say that it is acceptable under federal law to have a mandate. Now, there are potential prohibitions against mandating vaccinations due to the emergency use authorization status that currently exists. There are states that have taken positions that you cannot mandate a vaccine that is only under the EUA. We want to make sure that you provide all reasonable accommodations that are requested. Be prepared to defend any disparate impact claims with a showing of business necessity. Be prepared to show your vaccination policy is required to prevent a direct threat to established business necessity. And some additional caveats, we want to make sure that we're complying with all the ADA rules for disability-related inquiries and medical examinations. And of course, we must keep the vaccination information that's revealed to us confidential. Examples of pending state legislation. So depending on what state you're in is going to depend on whether or not there is a greater risk in asking about vaccination status. Some states have pending legislation that would make it unlawful to take an adverse action against an individual based on vaccination status. Also, it would disallow you from discriminating regarding tenure, compensation, employee benefits, or other terms and conditions of employment based on vaccination status. You also shall not coerce employees into consenting to a COVID vaccine. You can't withhold career advancement based on vaccination status. You may not inquire into COVID-19 vaccination records in certain states. You may not require mandatory disclosure of COVID-19 status. Also, there are states that will disqualify certain entities from receiving state grants or contracts if they engage in certain prohibitive activities. You may not deny individuals entry based on vaccination status, especially in places of public accommodation. Some of the basics, there is what's known as a vaccine passport, and there are many legislatures and executive orders that prohibit vaccine passports depending on your state. Most often they relate to government entities or public employers, but there are some that relate to private employers as well, including Florida, that prohibits employers from asking for a vaccine passport. The prohibition on vaccines as a condition of employment or discrimination on vaccine status. We are seeing this in some locations, mostly relating to public employers mandating employees receiving a COVID vaccine, but Montana did extend this to private employers. Paid time off to obtain and recover from that vaccine, we know, for example, exists in New York, Massachusetts, and Los Angeles County. And as of June 1, 2021, Santa Clara County requires proof of vaccination of all personnel. There is a form that must be completed and must be completed every 14 days for those personnel who are not fully vaccinated. If an employee refuses to receive a vaccine because of disability, pregnancy, or sincerely held religious belief, then it's important for you as the employer to consider whether the employee can be accommodated in the workplace and what that accommodation would look like, including remote work, leave or reassignment, or if there are any other rights available to the employee. In considering a reasonable accommodation, we want to look at the reasonableness and undue hardship of granting the accommodation. Examples provided by the EEOC of reasonable accommodations include wearing a face mask, continuing to socially distance, working a modified shift, getting periodic tests for COVID-19, given the opportunity to telework, or being reassigned. We really need to ask ourselves, if physical presence in the workplace necessary to perform the essential functions of the job? And if so, we want to make sure that our job descriptions reflect as much. EEOC disparate impact, as a reminder, because there are some segments of our population based on certain demographics, that it may be harder for them to receive the vaccine. So any requirement to be vaccinated to return to the workplace may be more likely to negatively impact employees of certain protected categories. Direct threat determinations. Whether an employee creates a direct threat to the safety and health of others in the workplace is an individualized assessment, and actually is a very high bar. It has to be a significant risk of substantial harm that cannot be eliminated or reduced through reasonable accommodation. The EEOC would say that we need to determine whether the employee works alone or works with others. Do they work inside or outside? Is there available ventilation? The frequency or duration of their direct interaction with employees or others, number of partially or fully vaccinated individuals already in the workplace, whether employees are wearing masks or undergoing routine screening, and space available for social distancing. We also need to look at how those direct threats come into play with OSHA and our state-specific COVID-19 protocols. Confidentiality of medical information, as stated before, we want to make sure that we're keeping the vaccination information confidential. So we don't want to inadvertently disclose an employee's vaccination status by making any kind of indication or mark on their badges, by designating a separate work area, creating odd or even days of when vaccinated and unvaccinated people come to work. Mask policies, we want to think about how we implement that and what we communicate with supervisors and customers. So the EEOC has told us that is okay to make an incentive to encourage someone to be vaccinated, but it cannot be coercive. So simply providing an incentive, either financial or additional time off or some other tangible object, an actual water bottle or some other logoed company product, these are all appropriate incentives. Best practices for employers. In terms of getting a vaccine, as a reminder, have a written policy. The vaccine should be mandated and encouraged. Determine if it's going to be just for applicants or for all or some of your employees. We want to be non-discriminatory in how we do this, so really think through how we would decide if not everybody is going to have the same requirements, and understand that employees may be eligible to take paid or unpaid time off for absences related to reactions where they feel ill after the vaccination. Best practices for employers when it comes to this in-person, remote, or hybrid workplace. Determine which model works best for you and your employees. Full-time office, full-time remote, some hybrid. Again, have a written policy. What are the office and work from home procedures or their designated days? Is there flexibility? We want to make sure that you're giving advance notice so that the employer and the employee can plan on what their work schedule will look like. And if you're going to have different requirements depending on the essential job functions, just make sure that you're not basing this on any type of discriminatory basis. We want to make sure that you're monitoring your policy and also that you adjust your policy as needed with notice to employees, because even though we're putting a policy in place, this is still uncharted territory, and it is possible that there are going to be tweaks and changes that are needed along the road. And thank you for your time. If you have any questions, I will be staying after to answer those that you may have. Thank you again.
Thank you, Dina. That was very informative. I know a lot of us are talking about what the next phase will look like. So it was very timely, I think, for all businesses, not just our importing members. We really appreciate you taking the time to put that together for us and for being here to answer questions. But so far, I don't see any. I missed a couple yesterday and Ed pointed them out, but I don't think, does anybody have any questions they would like to add to the chat room? If not, we can certainly give you Dina's contact information and let you contact her directly with any further questions that you have.
Okay. No questions. Okay. I hope that this was helpful or useful or gave you something to think about. But as Erin said, if anybody has any questions, they can always reach out to me afterwards. It's been a pleasure presenting to you today.
Thank you. I really appreciate you being here, Dina.
Thanks, everyone. Have a good day.
Thank you. We have two more educational sessions today and a couple of messages from our international colleagues. So before we get on to our FDA presentation, I'd like to bring in one of our international videos.
Hi, my name is Rodrigo Gutierrez and I'm the International Business Promotion Manager at the Spain-US Chamber of Commerce. First of all, I would like to thank the Association of Food Industries for organizing this amazing event for importers and letting me participate representing my country, Spain. All of you know that Spain is a great destination for tourism. It's full of cultural heritage, and meals there are not just food and beverage. They're a unique experience. But Spain is much more than that. Keeping the respect for the land and the product, Spanish fields and farms are full of agricultural engineers that have turned the country into the second largest producer in Europe. We don't only produce wine and jamón anymore. Now everyone knows our famous Marcona almonds, among many other dry fruits and nuts. Now, you probably hear this a lot, but Spanish products' average quality is extremely high. Take olive oil as an example. In the last 20 years, Spain has become the largest producer and exporter of olive oil in the world, and now thanks to its quality, our oils are overtaking Italian and Greek oils in grocery stores, not only in the US, but all over the world. How can Spain guarantee such a high quality? Well, the response is resources, knowledge, and dedication. Most of the Spanish agricultural products come from small family-owned ranches and historical co-ops. These families have combined the knowledge passed down from generation to generation with the latest agricultural techniques and technologies implemented by agricultural engineers that make sure that the quality remains high. In Spain, agriculture is not just a business, it's a tradition carried on by growers who love their products and their lands. That is why we're a major organic products producer in the world. Spanish professionals are ready to bring their products into the US, and American consumers are eager to find new, healthy, and green products full of history and passion. So please contact us to know more about Spanish products. And now, enjoy the rest of the convention. Thank you.
Okay, our next speaker, excuse me, is coming to us from the FDA. We turn our attention to some of the regulations affecting your business practices. Amelia Tedderton is joined by Angela Fields, each senior consumer safety directors with the US Food and Drug Administration, and they'll address the FDA's proposed traceability rule. Ms. Tedderton and Ms. Fields work in the Division of Import Operations within the Office of Regulatory Affairs. Their focus is on the Food Safety Modernization Act, FSMA, and while also providing authoritative guidance and training to FDA personnel, and also advising management on a wide range of regulatory issues and supporting the development and implementation of programs to protect the safety and security of imported food. Together, they bring a wealth of information on this important topic. So we'll begin their presentation now, and as always, they'll be joining us immediately following the presentation to take your questions live. Thanks very much and welcome, Ms. Tedderton and Ms. Fields.
Hi there. Thank you for inviting me to speak with you all during day 2 of the Association of Food Industries annual virtual meeting. My name is Amelia Tedderton, and I'm a consumer safety officer with the US Food and Drug Administration's Division of Import Operations. So I've worked in imports my entire career. Hopefully this helps relate to some of you all. I've reviewed entries, collected samples at the Port of Los Angeles International Airport, all the way to my current role where I support the development and implementation of programs to support and protect the safety and security of imported food. So today I'm going to be discussing FDA's food traceability proposed rule. otherwise known as requirements for additional traceability records for certain foods, as it's required under Section 204 of the Food Safety Modernization Act. So let's start by sharing the current state of things. Here are some examples of the types of records that FDA typically receives when we're conducting outbreak investigations. As you can see from the photos, the documents are often received in paper rather than in an electronic format. Information on the forms can be inconsistent and not standardized, so it lacks a deliberate method to connect all these records together. As you can imagine, piecing together information from several types of documents to extract useful tracing data at each point in the supply chain is time-consuming. From an outsider's perspective, it seems that this approach would be prone to errors. This significantly slows the tracing process and potentially puts more consumers at risk during an outbreak. So why is traceability important? Each day that a foodborne illness outbreak remains unresolved, the health of consumers remains at risk. FDA recognizes that to fully realize the public health benefits envisioned by the Food Safety Modernization Act, otherwise known as FSMA, we need to improve our ability to rapidly identify and trace foods that may be causing illnesses. So in order to trace foods through the supply chain, FDA needs accurate information on the food. Tracing a food back in the supply chain from the point of sale or service to a common source is important for identifying contaminated food or ingredients and removing those products from the marketplace to prevent additional illnesses. Tracing food forward can help FDA understand how the distribution of a food product relates to illnesses or illness clusters, especially for outbreaks that are challenging to resolve, such as those involving multiple foods and foods with multiple ingredients. So the proposed traceability rule lays the foundation for a standardized approach to traceability record keeping. While limited to certain foods on the food traceability list, which I'll review a little bit later, the proposed rule requires covered persons maintain records for those foods that will support more efficient and accurate traceability of potentially contaminated food. So the food traceability proposed rule was published back in September of 2020. Throughout November and December of last year, FDA hosted virtual public meetings, and then the comment period closed on February 22nd of 2021. We're now reviewing the comments as we work to develop a final rule under a consent decree, in which we need to submit a final rule to the Office of the Federal Register by November 7th, 2022. So the proposed rule has several intended benefits. When FDA can more quickly identify the source of contaminated food and remove that food from the market, we would help reduce the impacts of foodborne illness outbreaks and prevent additional illnesses and deaths from occurring. With more accurate information to help identify the source of contaminated food, we would be able to focus our recall efforts directly on the implicated products, rather than having to issue public health alerts across entire product categories or growing regions. When each point in the supply chain is maintaining the same information in the same way, more efficient traceability is facilitated. Harmonizing and standardizing traceability information would allow FDA to establish linkages along supply chains more quickly than we can do now. We believe our approach is consistent with current industry approaches in terms of identifying critical points in the supply chain where essential traceability data should be maintained, creating better alignment between FDA and industry approaches. Finally, with enhanced information about the supply chain, we would have more information to inform root cause analysis to identify and apply lessons learned from outbreaks to help prevent similar problems from occurring in the future. So let's discuss some of the key concepts of the proposed rule, beginning with who's covered by the rule. So the proposed rule covers any persons who manufacture, process, pack, or hold foods on the food traceability list. The proposed rule touches the entire supply chain, from farms to manufacturers or processors to distribution centers to retail food establishments like grocery stores and restaurants. Quite a few tongue twisters there. So the requirements also apply to both foreign and domestic firms alike. The proposed rule only applies to those certain designated foods on the food traceability list. And there are some exemptions and partial exemptions, as well as 2 options that are proposed with regards to retail food establishments. So as many of our rules work, as folks may be familiar with, unless a specific exemption is in place, the proposed rule would apply to all persons who manufacture, process, pack, or hold foods on the food traceability list. So this slide points out some of the statutory exemptions provided by Congress in Section 204 of FSMA, while others reflect our current thinking about application of the proposed rule. So I'm not going to delve too much into each one of these exemptions, as they likely don't apply to importers, but you can see them here and we can answer any questions you may have later. So as I've mentioned a few times, the proposed rule would apply to all persons who manufacture, process, pack, or hold foods on the food traceability list. Trying to work with repetition here. So that definition does not differentiate the role of an importer. So the rule would apply to importers of food who engage in manufacturing, processing, packing, or holding foods on the food traceability list. FDA believes that persons who do not physically possess food are not engaged in holding of food within the meaning of the proposed rule. This means that some persons who import food may not be subject to the rule if they do not physically hold the food. For example, a person who coordinates but never takes physical possession during the importation of a food included on the food traceability list would not be subject to the rule, while a person who imports a listed food they physically possess and hold would be subject unless a specific exemption applied. So one thing that we want to point out here is that even if an importer isn't subject to the rule because they do not hold the food, they may be asked by others in their supply chain who are subject to the rule for assistance when it comes to records maintenance. A firm may work with supply chain partners, such as third party of other firms in the supply chain, to maintain those records. However, any records required by the rule would have to be provided to FDA within 24 hours of the records request, regardless of where the records are stored. So let's review the food traceability list that I've brought up a few times. FSMA required FDA to designate high-risk foods for which the record-keeping requirements in this proposed rule would apply. To determine which foods should be included on the food traceability list, the Center for Food Safety and Applied Nutrition's Division of Risk and Decision Analysis developed a risk ranking model for food tracing. This data-driven science-based decision support tool, also known as the model, assists the agency in the process of designating a food traceability list. The model scores a commodity hazard pair according to data and information relevant to criteria required by FSMA. So for example, the model would look at the incidence of Shiga toxin producing E. coli 0157 in leafy greens to help make a decision about that product's inclusion on the food traceability list. The model was developed in conjunction with an FDA project advisory group consisting of members from FDA and the Centers for Disease Control and Prevention. The approach was released for public comment back in 2014 and underwent 2 separate peer review panels of independent external experts. Using the results of the risk ranking model, we tentatively identified foods for the food traceability list shown here. Again, foods on the food traceability list are considered covered by the proposed rule, and each proposed requirement in the rule pertains to all such foods unless an exemption applies. For most foods listed here, it would include all varieties or types, all variations, such as all varieties of tomatoes. Since tomatoes are listed here on the food traceability list, that would include other examples like Roma, beefsteak, cherry, whatever other varieties. Or all varieties of peppers like sweet peppers, poblano peppers, jalapeno peppers, etc. In addition, the food traceability list includes not only the foods specifically listed here, but also any foods that contain these listed foods as ingredients. So for example, peanut butter is on the food traceability list. So crackers with a peanut butter filling that do not undergo a kill step would also be covered by the proposed rule. If there is a kill step, as I mentioned a few slides back, record of the kill step application would have to be maintained by the persons who applied the kill step. For some foods, there are a few exceptions. For example, the category of fin fish would not include siluriform fish, such as catfish, as those are regulated by USDA. Additional detail on the food traceability list is available in a memo accompanying the proposed rule. FDA will publish a final version of the food traceability list when we publish a final rule. So we do intend to periodically review relevant data and information to determine if we need to update the food traceability list. However, we do not anticipate updates to the food traceability list to happen very often. If we determine we should update the food traceability list, FDA will do so via notice in the Federal Register, providing the public with an opportunity to comment. Like the proposed rule, we'll then review those comments and post a notice in the Federal Register, identifying any changes we decide to make. Any additions to the list would become effective 1 year after the date we publish any final changes to the food traceability list, unless otherwise stated in the notice. So now I'm going to review some of the other, what I call lingo of the proposed rule. So our approach to traceability in the proposed rule is one that's consistent with the current best practices in the industry. We've identified the key points along the supply chain where it's most important to collect traceability information. These are called critical tracking events. You may see them in the slides here listed as CTEs. I'm going to try to just say critical tracking events though. And that includes the points where food is grown, created, transformed, shipped, and received. So at each critical tracking event, or CTE, we are requiring traceability information essential to understand what's happening to the food at that point. These are called key data elements and will provide us with the necessary data to make linkages across the points on the supply chain and more quickly and accurately identify the food's movement through the supply chain. The key data elements are also referred to as KDEs. So the key data elements required by each entity depends upon the critical tracking event that's being performed. The records required at each critical tracking event would need to contain and link the traceability lot code of the food to the other relevant key data elements. By identifying the required key data elements, this will also help standardize the data the industry maintains for traceability. So the proposed record-keeping requirements would apply to all foods on the food traceability list, which includes products that contain listed foods as ingredients. Firms can elect how they would like to maintain their key data elements. However, they would be required to be linked to the traceability lot code. So a traceability lot code is proposed to be a descriptor used to identify a traceability lot that is assigned by a traceability lot code generator. This is similar to what industry currently refers to as a lot or a lot code. Traceability lot codes are an essential part of this rule, as all key data elements would be required to be linked to them in the records provided to FDA. We wanted to ensure that a single descriptor could be used to easily identify specific product lots, otherwise referred to as traceability lots in the proposed rule. Traceability lot codes stay the same throughout the supply chain unless certain activities are performed. The proposed rule allows for flexibility on establishing traceability lot codes. There are no proposed requirements on how a firm should create their traceability lot codes. For example, the traceability lot code could be a firm's only lot code, or it could be a different number used in addition to other lot codes used within that firm's internal traceability system. This is open for the best practices for each business to utilize. For foods on the traceability list, there is no proposed requirement to place or print key data elements on food products. Firms that manufacture, process, pack, or hold foods on the food traceability list would be required to create and maintain records of the key data elements that are relevant to the critical tracking events performed by that firm. Firms that ship foods on the food traceability list would also be required to send certain key data element information, including that traceability lot code, to the receiving firm. However, the traceability lot code and other key data elements would not need to be written on the package of the product. They could be sent in other ways, such as via email, or part of the documents that accompany the shipment, such as a bill of lading. At every critical tracking event, key data elements must be linked to each traceability lot code of the food to help make linkages within a firm and across the supply chain. This information will help FDA quickly go back to the entity within a supply chain that originated, created, or transformed the product. The traceability lot code stays the same as a product moves through the supply chain until a transformation occurs. In general, the entity who originates or creates the food is the one who establishes and assigns the traceability lot code, which enables FDA to skip points in the supply chain that minimally handle the product and quickly identify the points that can provide FDA with the information leading to the source of the product. So as I've mentioned a few times, the proposed rule would require every person who manufactures, processes, packs, or holds foods on the food traceability list to establish and maintain traceability program records. We know that traceability information is maintained in different ways across the food industry, and that these differences often lead to delays in the time needed to analyze tracing data collected from each firm during a traceback investigation. The intention of aligning traceability program records is to help us more quickly review and understand the information provided by a firm. While most of the proposed records would need to be retained for 2 years from creation, all traceability program records would be required to be maintained for 2 years following their discontinuance. Having a record of these changes would be helpful during retrospective outbreak investigations where historical cases were associated with an ongoing outbreak investigation. Additionally, persons that would be subject to these requirements may enter into agreements with individuals or firms to create and keep records that would be required for this rule on their behalf. So on the records maintenance and availability, the proposed rule would also require that records be maintained as either original paper records, electronic records, or true copies. Regardless of the form, they must be legible and stored to prevent deterioration or loss. Records must be kept for 2 years from the date they were created. Traceability records must be provided to FDA as soon as possible, but no later than 24 hours after a request is made. And finally, firms must provide FDA with an electronic sortable spreadsheet containing relevant traceability information within 24 hours of a request when necessary to assist FDA during an outbreak, recall, or other threat to public health. The proposed rule specifies that a violation of any record-keeping requirements under Section 204 FSMA is considered a prohibited act, except when the violation is committed by a farm. The proposed rule specifies that an article of food is subject to refusal of admission under Section 801A4 of the FD&C Act if it appears that the record-keeping requirements have not been complied with regarding such article. So this means, for example, that if we determined that an importer of a food subject to these requirements was not in compliance with respect to a food the person was attempting to import, we could refuse to admit such food. So a little bit more about compliance dates here. So if finalized, the rule would become effective 60 days after it's published in the Federal Register. Section 204 of FSMA directed the requirements to apply to small businesses 1 year after the effective date and to very small businesses 2 years after the effective date. However, persons subject to the final rule would not have to be in compliance until 2 years from that effective date. Although Congress established these later compliance dates for smaller entities, we believe that we could more effectively and efficiently implement the new traceability record-keeping regulations by having all persons subject to them come into compliance by the same date. An effective traceability system requires that all entities in the supply chain participate. Otherwise, there are holes in the system, making it particularly challenging to trace products further back through the supply chain. We're concerned that staggered compliance dates would hinder the rule's effectiveness. Therefore, we propose that the compliance date for all persons subject to these record-keeping requirements would be 2 years after the effective date of the final regulations. And finally, this last slide covers some resources found on our FDA website. Since there's quite a few resources here, I wanted to walk through how to find the most up-to-date information on our site. So I'm going to be navigating over to a different screen here, and hopefully I'll be able to walk folks through this. So I'm opening my favorite handy browser, and I'm searching for FDA traceability. And I'm just going to search on those specific things there. The first site that comes up should take you to an FDA page. We can check to see that it's an FDA.gov page here. And it's titled FSMA Proposed Rule for Food Traceability. So I want to point out here, let's see if I can make this a little bit larger, that a lot of the links that were referred to in the resource slide that I shared are listed here as well. So there's a lot of additional information about food traceability lists, key data elements, critical tracking events, etc. There are links to the food traceability list and all the information that's listed there. There's frequently asked questions that's available within a PDF. There are some other drop downs covering key features, exemptions and modified requirements, implementation information, that's about compliance dates that I covered. There's some contact us information I'll cover in just a moment. And all these supplemental materials are some of the materials that were covered in the resource slide. So I felt like this would be an easier way of instructing folks how to navigate through rather than sharing specific links, but we'll figure out a way to share those as well. So one last note from that slide is that, we'll navigate back so we can see this. One last note is that any additional questions related to the rule should be sent over to the FSMA Technical Assistance Network. So I wanted to navigate to that page as well. So on our FDA.gov page here, all the way on the left-hand side of the same page and most of the FSMA pages, there's a link to the FSMA Technical Assistance Network. So once we click here, there is a way to submit a question to the FSMA Technical Assistance Network. Sometimes it's called the TAN, and submit a question. There's also other ways to mail in your question and some other information about the Technical Assistance Network. That's it for me. And I think that we will have an opportunity for questions and answers. Thank you very much.
Thank you so much for that presentation, Amelia, and welcome to you and Angela. I think we have you both live here for Q&A, is that right?
Yes, thank you for having us.
I'm so glad that you're here. Couldn't be more timely with this proposed rule about to go into effect for so many people, so many of our members and attendees. We do have a couple of questions coming in through the chat or email and text. So let me start by asking you the one here in the chat room. I know you covered kill steps, but someone wants you to go over what the kill steps are that are approved by FDA.
Sure. So I will start by mentioning that we recognize that applying a kill step to a food can reduce the food's potential to harm public health by significantly minimizing the presence of pathogens in the food. So the proposed rule proposes to define kill step as a processing that significantly minimizes pathogens in a food. So examples of those that are included within the proposed rule include cooking, pasteurization, heat treatment, high pressure processing, and irradiation, as long as those processes are conducted in a manner that significantly minimizes pathogens in the food. So I'll pause there and I'll just see if Angela wants to add anything to that from her perspective.
Thanks, Amelia. Yeah, no, I think you've covered mostly how we would define kill steps. And again, if you have any questions related to the kill steps that you may perform at your facilities, please feel free to submit a question via the TAN, and then that way we can have a better understanding and get back to you.
Okay, that's very valuable too. Thank you. I have another question from our food importing members. Can you tell us a little bit about how traceability information is different than the supply chain management documentation that importers need for the FSVPs?
Yeah, so there are a lot of similarities, and I think that as we move forward and continue to finalize the rules, this is something that we're doing some gap analysis and comparing and contrasting. So I don't know of the specifics off the top of my head, and I would of course defer to Angela if she has any of these. But I think that what we're looking for with the traceability is some of this further tracing back and tracing forward information that is slightly different, but there is quite a bit of overlap with FSVP.
Okay,
Yeah,
great.
And
Go
so
ahead,
to
Angela.
I was
add
going
on
to say, Angela, to add on, thanks.
Yeah, so to add on to that, so basically the intention, as Amelia said, is to make sure that we're able to get to the source. So with FSVP, while you are trying to verify who's supplying the products that are being imported and ensuring that they're performing the adequate kill steps or adequate processes, safe handling practices that are necessary for that food product, the difference is with this traceability rule is that really what we're trying to get at is to get some uniformity across the board with terminology and the way that firms are capturing data, because in situations where we have product recalls or some type of product action, we need to ensure that we can quickly understand the information that's being provided to us by various firms. Across the supply chain, across the industries, across the commodities, there are pieces of data that are collected, but they're all collected in very different ways, and they're called very different things, but could be meaning the same thing. So ultimately, one of our major goals with this rulemaking is to ensure that we have the standardization, or at least begin the conversation of having a standardization, so that we're able to really understand the information that we're receiving from firms across the various industries.
All right, very good. Thank you. We're going back into a little bit more information on the kill steps. There's a two-part question here. are the kill steps under the FDA organic, and can the kill steps be done abroad?
Hey, I will kick off, and I might need some additional information on the kill steps under FDA being organic. I'm not quite sure. I think that if we're referring to organic terminology that USDA uses, I think that we might need to look further into what those requirements are for them. So if I could ask for some either follow-up information, or if Angela happens to be able to speak to that, I would definitely defer to her just on that first one.
Okay, I'll wait to see if there's some clarification put in the chat room on that question, but go ahead with the second about the kill steps being done abroad.
Yeah, so my understanding is that the kill steps, just depending on where they are within the processing, so depending on where the food is in throughout the transformation process. So I think I spoke a little bit about the entire food as it goes through, an original ingredient into being formed into something else. So it just would depend on where the kill step is in that process, that part of the process, if that helps. Angela, is there anything else that you can add there? Thanks.
Sure. So regarding the kill step being done abroad, yes, the kill steps could likely be done abroad if that's the way that the manufacturing process goes. The requirement of the rule would be, again, that we would like some documentation to show where the kill steps occurred. So regardless of wherever in the supply chain the kill step occurred, as long as there's documentation to show that that happened and that we can be provided that, then there would be exemptions for following 204, FSMA 204, in which then firms would only have to comply with the Subpart J requirements that are currently there, the Bioterrorism Acts of 2002, Subpart J.
Okay, thank you. I don't see any clarification on the other organic question, but I'll go on to one in the chat room I see now. I'll read it to you. Does the FDA have preferences on companies they prefer for manufacturers to work with on creating FSP and FSVPs?
Can you repeat the question, Erin? Is this sound like it's an FSVP question?
It looks like it is. Does the FDA have preferences on companies they prefer for manufacturers to work with on creating FSP and / FSVPs?
Okay, and I think I'm hearing that as food safety plans and like for supplier verification programs.
Yes.
That not being the focus of this here today, I'm just shifting gears a little bit mentally. So my understanding is there are not specific firms or facilities that we defer to or refer to or have as references for developing those, so long as they meet the qualifications in the FSVP rule, or whatever those food safety plans are being used for. If there's some additional clarification for this question, of course we can take it. Or as Angela mentioned before, I think that might be a great question if folks want to send that over to the Technical Assistance Network. They might be able to put you in touch with specific folks working with FSVP that might be able to better answer that question.
Okay, I appreciate that. Thank you. I thought I saw one more question, but I think that might be all we have. He might have answered it in some of the other answers. Okay, so here's another, there is some clarification in the chat room real quick. I just wanted to know if all kill steps maintain the status of organic of a product.
So I'll definitely, I think as I was mentioning before, I think my understanding is that the organic status of a product is something that USDA has some more definitions for. So I think that just regarding that, as far as I understand, and of course I'm just kind of speaking off the cuff here, that I think that you would have to check with them to see about, what sort of kill steps would maintain the status of the organic status of a product. Angela, is that something else that we could speak to?
Yeah, I think you answered it correctly. That USDA obviously being the person the entity that's assigning that designation, that they will have more information about whatever standards would be necessary to meet and comply with that. I will say though that in our rulemaking process, and even as we're moving towards the final rule, that we are, having discussions and doing a lot of crosswalk and cross analysis of various rules across the agencies, to ensure that we're not conflicting and to ensure that we are trying to be as harmonized and uniform as we can, or to take into account what kind of situations may arise if you are complying with a different regulation. So again, it is our intention to try as best as we can to ensure that we're taking all of those things into account as we move forward towards the final rulemaking.
Very good. Thank you, Angela and Amelia. I want to thank you both for taking the time to prepare this presentation and share this information with our attendees and U.S. food importing members. I'm hearing a strange noise, sorry. I'd also like to thank our sponsor for today, the Flavor and Fragrance Specialties, and I invite you both to come back and visit us when we are gathering in person. Thanks so much for your information.
Thank you so much for having us.
Oh, yes, you're welcome. Thank you. Moving on, we do have a message from one of our international colleagues.
The world has changed. Consumers shop 24/7. Goods are coming from all over the world, and they expect these products to be available and in stock. If not, they will quickly move to another banner. Supply chain players are not aligned, and they need to face problems of a different nature, like out of stock, out of codes products, overstock, and inefficient production. The focus must then shift to a demand-driven supply chain, switching to a more frequent direct distribution center replenishment based on recurrent demand. With more than 30 years of experience in exporting products worldwide, Adra Logistica has created CSI, Cloud Sourcing Intelligence, a proprietary software that generates automated replenishment programs by connecting and analyzing the information coming from all of the supply chain players. Through CSI, Automated Replenishment Program will provide a purchase order proposal once a month to the replenishment buyer and a 3 months in advance production schedule to help manufacturers plan their production while reducing cost and the impact on the environment. It's easy to start with only 3 easy steps. First, historical scan data or warehouse cases movement on distribution center basis. 2, weekly inventory report on distribution center basis. And finally, 3, promotional plan. All players will experience multiple advantages. Retailers will benefit from more competitive prices, fresher products on shelf and items always in stock. Distributors will drastically reduce their financial liability in terms of products on hand, setting a safety stock based on sales and replenishment. No more out of stock or overstock. Vendors will better manage lead time and shutdown, deleting all liabilities for products being stored in third-party warehouses and eliminating all inland shipments. Manufacturers will plan productions ahead of time thanks to a 3-month purchasing schedule. Every month they will receive from their client an official PO, allowing them to plan the purchasing of raw materials, packaging, and setting the production space. It works. Adra Logistica carried out a pilot program for a U.S. retailer with more than 400 stores served by over 10 distribution centers, reducing more than 75,000 cases of products in stock and saving over $2 million of liability, with huge savings for all of the players in the supply chain. Automated Replenishment Program also offers the opportunity to enjoy other simplified services like FSMA compliancy, mixed pallets, in and out, and seasonal programs suitable for either branded or private label programs. Adra Logistica's mission is to make the supply chain smarter, using intelligence and data sharing for more competitive goods, reducing the impact on the environment. Adra Logistica, delivering passion.
Okay, our next
Greetings from Côte d'Ivoire, the world's largest producer of cashew nuts.
Hello everyone, I'm Luceni Kone, President of Ivory Cashew, an AFI member company. I'm delighted to be greeting you from Abidjan, Côte d'Ivoire, where we are pursuing our effort in helping the Cashew Regulatory Authority and help the thriving young processing factories to be trained, certified, and comply with all US law and regulation, especially the FISMA law. And we'll be delighted to welcome you in Côte d'Ivoire soon. Thank you.
Adama Koulibaly, the General Director of the Cotton and Cashew Council of Côte d'Ivoire. I am pleased to have been invited to speak by Maryland-based EFI member company Agro Cashew during this prestigious annual convention 2021. Speak as a selected foreign partner with EFI with the great support of Mr. Bob Bauer. Côte d'Ivoire is motivated to advance its vision under my leadership, which enjoy national support. Our vision is to increase quality and food safety standard of production, meet US regulatory requirements, and to have our national brand of cashew come to the US market directly across the Atlantic Ocean. We opted to optimize our production technology, training, and food safety measures. While many of our processors have already met European or other global standards, we are excited to continue to rise the occasion of US food safety leaders. We used the temporary closed border of COVID to prepare as an industry which has shown great success in achievement milestone across our entire cashew industry this year. We are proud to note that more than 30 cashew processing facilities have been trained and nearly 13 processing plants have already been audited by FDA approved auditor along with the requirement for safety plans. We have a lot of talent in this country, as we have been agricultural leaders, and we are using their skill to our rise of the value chain and to enter the greatest market of our grand vision, the USA. We are excited to continue to learn and grow with you. We require our leadership. We are excited to continue to learn and grow with you. We require your leadership position in food regulation and market trends as foreign partner. Active participation is essential and mutually beneficial. Welcome to Côte d'Ivoire, as we say, Akwaba.
Okay, welcome back. Thank you to our friends and colleagues at the Ivory Coast for that message. Our final session for the AFI annual convention is the one we spoke about on cybersecurity. It's being sponsored by Coughlin Insurance Services, and it will feature 4 experts in the cybersecurity industry. We've all been hearing in the news on practically a daily basis now how important protection against cybersecurity or cyber hacks and ransomware has become for a business. So it's vital to know how to protect and what to do in case of an attack. We have Ms. Karen Painter Randall is here with 3 of the experts that she works with on a regular basis. She's a partner and certified civil trial attorney at Connell Foley, LLP, where she chairs the cybersecurity, data privacy, and incident response group. With extensive experience advising on cybersecurity, data rights, and privacy laws, Karen provides proactive measures to safeguard enterprise data, including security assessments, policies and procedures, security awareness training, incident response plans, and cyber liability insurance. Importantly, she also serves as an incident response counsel, leading the incident response effort quickly and efficiently on crippling data breaches, particularly those involving insider threats, wire transfer fraud, business email compromise, and ransomware attacks. Ms. Randall has put together this amazing panel for us today. I'll let her tell you a bit more about their shared experiences, but I'll introduce them first. Is John Dernberg, who is a national director of Gallagher's cyber practice. He supports prospect meetings, strategic reviews, approaches specific prospect opportunities. Mr. Dernberg has held roles in cyber sales, placements, claims, risk management, presentations, and the development of cyber-related articles and other materials, both for internal use and for sharing with clients and prospects. He's completed his undergraduate work at Yale and followed by law school at Columbia. Next, we have Mr. Brian Conlon, who comes to us from Star Adjustment Services. He is a 20-year insurance executive with over a decade of managing teams across financial lines. He is an honors graduate at Rutgers Law School and the head of the cyber and professional liability claims team at Star Companies. He's achieved the designation of Certified Information Privacy Professional in the United States. And then we have Mr. Alex Weintraub. Mr. Weintraub is an incident response lead at Arete Incident Response with over 10 years of experience in information and technology, security operations, and incident response. I'll turn this over to Ms. Randall now because they have significant information and experience to share with you today. The 4 of them will have our discussion and will be here afterwards to answer questions. So Ms. Randall, you want to begin? Is Ms. Randall with us?
She may be muted.
Possibly, but why don't we let you kick things off for us, Mr. Dornberg?
Okay, well, I'm gonna welcome and thank you, Aaron and team, for inviting us to talk about this very timely subject. There's a lot to talk about, a lot you're hearing about in the world today from a ransomware perspective, and many things you can do to protect yourself from an increasing risk and an increasingly costly risk.
Yes. Aaron?
Karen, okay.
I think Karen is with us now.
Yeah, we were having a hard time getting on for some reason. I don't know why. Hi, Aaron. Hi, Brian. Hi, John. Where's Alex? Is he around?
Yes, the other 3 are here and happy to welcome you. I'm sorry you've had troubles, but I'm glad you made it and welcome.
Okay, great. Thank you.
I have already introduced the panel and let them know that you will be conducting a discussion between yourselves and you and the 3 experts that you work with on a daily basis.
Okay, you ready for us to start, Aaron?
Yes, please go right ahead.
All right, well, we have a lot to talk about today, that's for sure, and welcome everyone to this program. I want to thank my fellow panelists. I think you've already been introduced by Aaron, but I want to personally thank you all for joining us today. So let's start by setting the right tone.
The intelligence community has been talking about the warning lights for cybersecurity blinking red for several years now. Chris Wray, the FBI director, just compared the ransomware threat landscape to 9/11, and most recently, our energy secretary has confirmed that our adversaries certainly have the capability of shutting down the electric grid. So ransomware attacks are not about losing data only. We have now gotten to the point that they're affecting our critical infrastructure. As everyone knows through the news, it's affecting our pipelines, it's affecting water treatment plants, it's affecting the food supply, which really should be relevant to today's discussion. Cybersecurity has become the wild, wild west of the internet. Let me move the slide here. Is this it here, Aaron? Nope, that is not it. Excuse me for a second. Do you have that there, Aaron?
Are you sharing your screen, Karen?
Yes, I am.
There we go.
Okay.
Perfect. Thank you.
Right. So let me get everyone back on track. As I was mentioning, cybersecurity really is the wild, wild west of the internet. That's why I like to start a program with this cartoon. The bad guys don't need to rob banks anymore. They're monetizing information from the comfort of their home, stealing the new oil of the 21st century. The personally identifiable information, the proprietary information, the personal health information. And if they're not stealing it and simply selling it on the dark web, they're now extorting it from you through ransomware attacks. And those types of attacks are getting more complex as well. So let's go into the type of cyber attacks that are out there. You see ransomware in the red. Alex, Brian, John, would you agree that ransomware now is the #1 cybercrime that's going on out there?
Without question. From my perspective, John may have a broader perspective, but from STAR's perspective, it definitely is the #1 cybersecurity incident that we see almost every day.
Alex?
We talk to insurers
Go ahead,
all
John.
day, every day, and from a cost perspective, ransomware is far and away the greatest exposure. Some carriers are, say, 70% of their cyber-related claims are ransomware claims.
Alex, what's your thought? Alex, I think you're muted.
Double muted. So I'll make sure to check that one off my bingo box. Yeah, with ransomware, we're seeing really high demands coming out right now. We're seeing about 60 to 70% of our workflow is going to be within the ransomware arena. Business email compromise, unauthorized access are those next ones that are in there. Socially engineering and other stuff are additional suspicious activities that are going on within environments. So yeah, we're getting a lot of view of what these threat actors can do and the sophistication of these threat actors within, every single one of the industries.
So Alex, why I have you on, for the audience's sake, we're dealing with the food industry. Could you provide them with a simplified version of really what ransomware is? That the name in and of itself sounds awful, and certainly the attack is as well. But just describe what ransomware is, if you would.
Sure. So ransomware, at the simplest terms, is unauthorized someone is accessing your environment, taking a lay of the land, and encrypting all your data. So you are able to see all your data, but it's inaccessible to you. And the only way to retrieve your data is to communicate with the threat actor and get to pay for your data back. It's essentially a robber stealing your data right in front of your face and saying, oh, you want this back? Well, then pay for it, and I can give it all back to you. And this is their business structure, and this is how they run.
Yeah, and so, there are various ransomware things out there that people like Alex and myself as a breach coach will see and work with. We reported back certainly to people like Brian Conlon, who's in the insurance industry. John is certainly aware some of these things as well. These are just some of them. There are deadlines sometimes on the slide. I'd love to hear everyone's feedback, but I'll start by saying I think IT within any organization should be instructed, should be trained, should be educated about what they may see on the screen if there's a ransomware attack, if there is a deadline, if there is something that they would click that would start the deadline running in terms of responding on whether or not to pay a ransom. We don't want them, we meaning the incident response team does not want them to click on anything that would start a deadline running. It really makes the response effort a little bit more complicated, and it could also add insult to injury by having that ransom amount increase twofold, threefold. Anyone else want to chime in there on deadlines? Any horror stories that you want to tell?
Just to give you some more color on how this generally works is you can, you'll receive a deadline often, and they'll say unless you pay up by this deadline, the ransom will double. And normally the payment, regarding instructions for payment, normally the payment will be required in Bitcoin, which is awful difficult to trace. And in return for paying a ransom, you're generally given a decryption key, which will help you unlock your system and gain access to your data.
Correct.
And you also have to find the balance between acting fast and acting hastily. If you attempt to back up from backups too quickly, you can infect your backups as well. And I defer to Alex, Brian, and you, Karen, on that. But we've heard many horror stories of IT people thinking they had workarounds and causing themselves greater heartbreak down the road.
Yeah, I think that gets back to my point that IT is part of the incident response team, and we'll talk about that a little bit later. But I think all of them, based upon my experience, need a little instruction. I mean, I think they can pick up on the fact that your organization might be in the midst of an attack, but then we want them to mitigate and not do anything until the incident response team is assigned to the response effort. So just educating them on what to do and what not to do if they think an attack has started. These are just samples of what your workforce or your IT or anyone else might see on their screen when an attack starts. Again, educating workforce of people, educating your key stakeholders, your IT about what to spot, and if they spot it, where do they go next? Who do they report the incident to? What next step are you prepared to take if something like this is on the screen? I mean, just imagine coming into your office and having someone tell you that they see this on the screen. You're in the midst of an attack. You can't use your computers. You can't use your mobile devices or any tablets, and you are basically shut down for possibly 2 to 3 weeks without any communication. So we'll talk about the importance of an incident response plan and team in a couple of minutes. Alex, Brian, and John, I'd love for you to comment on these stats. These are new stats, ransomware stats. They get rolled out periodically by key organizations. This is a Q1 2021 stat, which is pretty significant. Last year, we were looking at these stats, and we were pleased because some of the amounts of ransom payments were actually going down, not up. Brian, what is your thought on the average ransom payment now being $220,000?
Well, you know, from STAR's perspective, that would be a welcome sight because the demands that we're seeing, well, I know it's a ransom payment, but seems to be higher than that. To me, it's trending higher. I think the threat actors are doing a lot of research on the front end to determine who is a rich target. And, they look to things like, how profitable the target is, the company, if it is a company, and whether in fact they have insurance. So they do a lot of work on the front end. They've become much more businesslike in assessing who is an appropriate target.
Yeah, I tend to agree with you. I thought the average ransom payment was low too. I guess, you know, there's some attacks that are going on that might be pure extortion, meaning, you know, they just want to get a quick hit on a payment and they move on, a spray and pray type of attack. But the attacks that involve exfiltration of sensitive data, and we'll get into that in a second, seem to come with a prior price tag. I will mention on the slide, you see 77% of ransomware attacks involve the threat to leak exfiltrated data. So we are seeing more and more of those attacks take place.
And Karen,
yes, go ahead.
There's kind of a bifurcation in the market, as Brian said. They like the very rich targets, big companies with a lot going on, but the attackers are very opportunistic and they're checking the locks and the doors. And if there's a smaller organization, one that may not have robust security controls, has limited budget for these kinds of activities, they'll go in there and attack them as well. And those are some of the lower payments. The demands are not plucked out of thin air. They're often tied to things like a week of your revenues, as Brian mentioned, whether or not you have an insurance policy, if they can get that online. So they're very opportunistic and very targeted in how they go about it.
Absolutely. Although we do see some lone wolf attacks as well, and they're not as sophisticated, but unfortunately, even though they lack the sophistication, they can be more dangerous. This next slide talks about the most common ransomware attack vectors. It used to be phishing, you know, every year, every quarter, these things change, but, you know, this intel, this information is very important for you all to be sharing with your incident response team, especially with your IT, any vendors that you're using to monitor threats. Remote desktop protocol connections are now the #1 ransomware attack vector out there. So with that being said, Alex, what advice would you give to people watching this webinar with regard to remote desktop protocol connections?
So I'm going to make, and that's a really good question, Karen, and I'm going to make everyone aware of one more attack vector that has come out at the end of Q1 into Q2 of this year, and that is the Microsoft Exchange 0-day that came out in late February, early March. And what we're seeing with a lot of these variants, the ransomware variants, is they're utilizing this and taking advantage of everyone out there. We're looking at over 20,000 more exposed servers to the internet, exposed Exchange on-prem servers. And what this allows is the threat actor to easily access just random people, anyone's environment, drop a remote access Trojan, which is a type of tool for users, for these threat actors to actually access your environment and then be able to drop things in there, like Cobalt Strike, which is a tool used by red teamers or red teamers or purple teamers, which is basically the offensive side of what we do. And in addition to that, what else they'll drop down is ransomware, or they'll drop down credential harvesting tools, etc. From the RDP side, we're seeing multiple variants also using that. Sodinokipi love using RDP. That's one of the variants out of Russia. They've been in the news over the last few months related to a few of the attacks that have gone public. Conti, a new variant that's come out over the last 2 years, that they started utilizing this as well. We're seeing that with the newer variants, and I think on the next or the slide after, we're going to talk about different variants, and some of them have been popping up with a lot more traffic, and we're seeing that being utilized a lot. In addition to that, phishing is always the easy way of getting into an environment. Just sending off, hey, can you click on this document and view it? And people are, you know, unaware that these threat actors are still doing that, and they just enable editing on documents. And when you do that, you're allowing them to automatically just access your device. So just taking that 2 steps and saying, hey, did Dave send me this? Or did Brian send me this? Was I expecting this? Is this really his email address? And this doesn't only go for ransomware, but it goes for the business email compromise. We're seeing that being utilized with wire fraud. people just, these threat actors utilizing emails to phish people into submitting credentials. So just taking 2 steps or 3 steps back, looking at the email, making sure that it's legitimate, making sure it's from a client or a third party that you actually know and it's their email address, and then clicking on it or then, accessing the website.
So my first question, because I know everyone in the audience is saying, what is the answer to the question with regard to remote desktop protocol connections? If they're open, I guess the quick answer is please close them.
Close it. Yeah.
Exactly.
Right away.
Yes.
RDP should never be open to the internet. And if you needed that, if you need remote desktop to being open to the external internet, to be putting it behind a VPN, a virtual private network. And that is something that we also highly recommend doing. In addition to that, running a multi-factor authentication implementation as well. Anything that could be accessed from an external source not only should have a password protection to it, and a password that should be changed every 30, 60, 90 days with a password management policy, but also implementation of a multi-factor authentication policy as well.
Yes, and we'll get into some of the best practices later in the program, something that you all could probably easily share again with your organizations. Again, here's another significant stat. This jumps around on a quarterly basis as well. It used to be healthcare. Now it's professional services being the #1 target with regard to some of these ransomware attacks. Alex was just talking, I think Brian mentioned and John mentioned some of these ransomware types. We call them variants. We also call them strains. And when I say we, a lot of the people on this call will be part of an incident response effort. There are some that will be part of the incident response team along with your organization. That would be someone like Alex from Arete, to help with the forensic investigation. Also myself, my firm serves as a breach coach. I don't know why they use the word coach. I sometimes use the word incident response counsel because we are giving you the benefit of the attorney-client privilege. And then certainly people like Brian who are part of carriers, star companies, and John who certainly is helpful during an incident response effort to help clarify any questions with regard to insurance. But, we've spoken about these strains, the ransomware types, and you may be saying this, why do I want to be concerned about these strains? It looks like alphabet soup. Well, these strains are very important for us to know very soon in the incident response effort. They all have their different personalities. They all come from different regions of the world, and they all basically have their own focus on different types of industries. For example, the food supply industry, or pipelines, or professional services, manufacturing, construction. They have their own goals in mind. And so this is the top or the most common ransomware variants. When you have an attack and you get your incident response team together, your breach coach and forensics will ask a very important question. And that is, what is the ransomware strain? What are we dealing with? Some of them have the ability to exfiltrate or steal sensitive information from your system, which will most likely result in notification to the consumer, and some don't have the ability to do that. So that gives us a clue upfront very quickly. Very important for your IT to be able to spot those extensions, or to at least be able to share with us a screenshot or the identity of the ransomware type. We won't run with that 100%, but it certainly gives us some good intel to work with early on.
Can I add something here, Karen?
Yes, go ahead, Brian.
So in terms of the strains of ransomware, as Karen said, it's important to get that information as soon as possible. And one of the things, pieces of intel that it does provide you is, so at the end of this, if you do pay a ransom, you get a decryption key. Well, you want to feel comfortable that when you pay the ransom, the decryption key that you do get from the threat actor will actually work. And so these ransomware strains have reputations as to whether in fact they do provide decryption keys, do they come back once you've paid the ransom and ask for more money? That's another thing. Can you negotiate with these ransomware strains? How much can you negotiate? Do they have a history of actually, if you don't meet the deadline, doubling the ransom payment? So as Karen said, you do get very good intel by having your forensic firm that you retained to help you with this, identify the ransomware strain.
Absolutely. And that's a very good point, Brian. And at this point, we could probably just mention it. Sometimes, you know, when we're dealing with these ransomware attacks, depending upon the circumstances, and we'll get into whether or not you pay, you don't pay when there's a ransomware attack. But, you know, once we start the investigation and we know what we're dealing with regard to the ransomware group, we know what's going on within your organization with regard to backup, no backup, what type of information might have been compromised or is at risk. Sometimes if we want to negotiate with the threat actor, we do it for two reasons. Number one, you need to consider payment because you want to get the key in order to unlock your systems to retrieve your critical assets, your sensitive information. You just have no choice, and we'll get into that. Or sometimes we will buy ourselves time and we'll use a ransomware negotiator to actually engage with the threat actor to find out exactly what they have. You know, sometimes they will offer us a sample of the files that they exfiltrated. Sometimes they'll give us, you know, a sample key so that we can test it to see if it works before we want to make the next step on whether or not to pay within any ransomware attack. So let's, yeah, go ahead.
Karen, I can add from the insurer's perspective, and we negotiate on your behalf with insurers, having an ecosystem utilizing advisors like Karen, Alex, and Brian is worth a lot to them because they want to minimize the cost to them of resolving a ransomware attack. Sometimes that might be through payment, sometimes it might be through recovery, but it's really important for them that you operate within that insurance ecosystem with advisors who know how to negotiate and identify and deal with a ransomware attack in the most effective and expeditious way.
Yeah,
go ahead.
Sorry, Karen. And on that point that John and Brian made, which were really good points, is there are a lot of different phases within a ransomware infection, and it's really important to engage with your cyber, if you have a cyber carrier, cyber insurance carrier, on how you deal with this process beforehand, and just getting a little insight on if you were to get infected. And I'm saying every single industry is getting hit right now. The uptick in ransomware is higher than we've ever seen. We also see Washington talking about this almost every single day now. And so just understanding the process, contacting your carrier, getting some cyber insurance plan in place, and then being able to build out an incident response plan. It doesn't matter how small of a company you are or how big of a company you are. A lot of these variants will just spread out a phishing email to thousands of email addresses, and one person clicks on it and they make all their money from that. Sodinokibi are very well known on hitting very high value targets, but there are times where they thought wrong and they hit a small business, or they hit a diocese, or they hit a little small gear shop in the middle of Idaho. It doesn't matter to them. They want the money, and that's all they want. So engaging with Karen and her team at Connell Foley, engaging with John and his insurance, where he works for insurance, engaging with a team from Brian's perspective, really helps you throughout the different phases. In addition to that, when it comes to paying a ransomware, there are a lot of issues there because even from our side as a company that does communicate with threat actors, do negotiate on ransoms, is making that payment. And all our payments are actually reported through the Department of Treasury, through the Office of Foreign Asset Controls, to confirm and make sure that the payment is allowed. There are variants that are sanctioned entities from the United States that are basically interconnected to terrorist organizations, and we are unable to pay those. So working with Karen and her team to be able to assist with that is really important.
Yes, thanks, Eric. Alex, we're gonna get into the OFAC sanctions in a little bit. I want to move things along, if I could. Let's see. Okay, so, why are threat actors using ransomware? At this point, you're probably all saying, "What? We get it." It certainly is very profitable for them. I think someone mentioned early on, and maybe not, the ransomware as a service. The commoditization of malware has really had an uptick. Alex, Brian, John, do you want to comment upon that development?
I mean, they do operate as businesses, and so they do have a structure. And so you can get a malware kit on the internet, and you actually pay the makers of the malware a cut for actually using their malware. So you don't actually have to be a computer expert anymore in order to engage in these type of activities. So we're seeing it. I think that's really also one of the reasons we've seen it proliferate as much as it has, the commoditization of it.
Someone figures out, how to gain access to an organization, but they don't want to be involved in that attack. So they give the ability to attack, and this is on a simple level, they give the ability to attack to someone else, to an affiliate. And if they're successful and they recover ransom, they take a split. So they don't take on the risk by actually propagating the attack, but they certainly get paid for it. And that's what DarkSide was with regard to the Colonial Pipeline case. I don't know whether or not you all know, but you should be very happy to hear that the Department of Justice and the FBI were successful in recovering 2/3 of the ransom that Colonial Pipeline actually paid to the DarkSide group. The old adage, follow the money, actually worked in that case. They went through 23 electronic accounts, found the account that had the money in it, got a federal judge to issue an order to take it, and that's exactly what they did. So kudos to them, and I hope we see more of that activity. So, you may be saying to yourself, what are they looking for? Are they looking for food? Are they looking for gas supplies? Are they looking for information? As I said very early on in this program, it's not all about stealing data like the crown jewels and putting it on the dark web. This is just an example of what the crown jewels are. You'll see biometric data. That's been added in some states as a definition of personally identifiable information. So if you use fingerprints or any type of devices to collect that information, just be aware of the privacy and the cybersecurity laws that apply to it. This, simple stat.
Karen, can I add on that?
Absolutely.
What Karen just talked about also reflects the biggest change in the ransomware and insurance industry. It used to be that only companies that had a lot of personally identifiable information and protected health information needed to worry much about ransomware. They were the early buyers of cyber insurance. But now, as my co-panelists have been saying, all industries, whether or not they have huge amounts of that information, are subject to attack. It's easy for the attackers to monetize it. They shut down your business. They attack your controllers. You lose a lot of money, whether or not you have more information than just that of your employees.
Okay, so I'm trying to get to, and I apologize. Alex, can
Press
you
the
get
left
me?
arrow.
Yeah, I did. It's not getting there. How about that? Okay,
Oh,
there
there.
we
Here we
go.
go.
Thank you. We're back on track. Brian was so interesting that we lost our place here. Just interesting stat. China's already stolen 50% of the personally identifiable information in the United States. Let's just talk about this model. This is a developing model, but you'll hear in a second that there's even a more sophisticated model than this model. And this is what I think Alex had mentioned before. The attacker comes, they drop their malware, they conduct reconnaissance to find out where your crown jewels or other important information is. They exfiltrate through their tools. This sensitive could be sometimes highly embarrassing information from your system, and as they go out the back door to detonate the ransomware attack, they take it with them. It certainly puts them in a position of strength when they come back with the ransom demand. And sometimes if they have highly sensitive information and great volumes of it, that will drive the amount of the ransom demand that they're asking for. We just list the Grubman law firm as an example. That was a $40 million ransom demand. The Grubman law firm represented celebrities. They had NDAs, all sorts of confidential information on people like Elton John, even President Trump, Lady Gaga, and they threatened to post it. Brian and John, do you know, did they ever pay a ransom? I never saw any news about that.
I didn't see any news either. So oftentimes they try to keep that part of it silent so that they're not subject to a further attack because people know that they have paid a ransom. So I don't know the answer to that one.
Yeah, this is the most recent development that we're seeing. I have a case right now where the threat actor attacked a school, and we're in the middle of negotiation again to stall, not to pay, and they have threatened to send emails to the parents and students, request maybe even additional ransom amounts if the school doesn't pay. So that's, you know, not a good thing to happen in any case. They are getting very bold and brave. And just in that case, we actually did get the FBI involved pretty early on. Alex, what are you seeing? Do you see a lot of DDoS attacks follow in these types of ransomware attacks?
Yeah, we're seeing every single way that could be used by a threat actor to get paid. And they will go in the most uncomfortable means to get that payment. So DDoSing the environment, shutting down your capability of doing work, your business as usual. Emailing, we've seen emailing of the suspected patient zero saying, hey, you are our initial entry, you've turned off your device, you need to turn it back on. We want to be back in that environment to reinfect it if needed. Hey, we see where you're using cyber insurance. Hey, we see you're using a, AirTag, just our company. They are very, very sophisticated in their means to make sure that they get paid. Back in 2018, we were just seeing, encrypted environments, just people, the threat actor encrypting devices. But 2019 really changed that when Maze came out and when Sodinokibi or Rebel came out and started stealing data, exfiltrating data. And they said at that point in 2019 and early 2020, this is going to be the new way, the new tactic that we'll be utilizing up until now when, it's up to you, Karen, on if we want to make that payment or not. Hey, instead of making that payment of $3 million, you can notify these 3,000 employees and just do, dark web scanning for them for the next, for the rest of their life. And it'll only cost you maybe $200,000 out of pocket. So you have to figure out the variables there. So yeah, they're going out of their way to make us feel uncomfortable and make the clients and suspected victims feel uncomfortable.
Can I add something? So when you're faced with a ransomware attack, obviously one of the things that you could choose to do based on, taking all the factors into consideration is if you do have viable backups offline on another system, is create from backups. And so the ransomware threat actors saw that happening and they're thinking to themselves, all right, how do I get around that? How do I actually get paid even if they do have backups? And this is the route that they've taken. They've taken exfiltrating the data and threatening to release it, and this triple extortion example as well, to get around the fact that some of their targets may have viable backups.
Right. And that's why it's so important to have a strategy in place, to be aware of the intel that is out there, the type of attacks that are going on, to share the intel with people, because you're going to have to bob and weave a little bit during these incident response efforts. The case that I was just mentioning to you, we have no intention certainly of paying. We are buying as much time as we can. The threat actor has reduced their ransom demand to our first offer, but we have what we need in terms of identifying the systems with the sensitive information, having the backup in place. We know that they have taken information though. They gave us sample files. So what are we going to do about that? We're going to get as much or make as much progress in that incident response effort as possible. And when the ransomware negotiator is getting ready to disengage because we can't do anything more with the threat actor, we will be in a good position to have rolled out messaging to warn people to have that notification in place if personally identifiable information has been impacted and exfiltrated. So it gives us stronger ground to stand on before the threat actor gets angry because they didn't get paid in that case. But every case is different, strategy is different. That's why the team and being prepared is so important. So let's move to the next slide. Brian, you want to address this briefly? I want to make sure we keep a good pace here.
Sure. So one of the things that when our insureds are the victim of a ransomware attack, that they're most concerned about is the potential damage to their reputation. Another thing that impacts them significantly is that they're not able to conduct business, generate revenue and profits. And so you lose productivity, reputation, downtime. You also have, major employees of the targeted company having to take a lot of time and effort in trying to resolve this. You have costs of a forensic investigation. You have breach incident response counsel that's been retained. So the costs are significant, and a lot of these costs can be mitigated through the use of an insurance policy. Sometimes you have to retain a public relations firm to deal with the reputational fallout. That's something that's covered under a lot of insurance policies. But the costs really can be catastrophic for some companies.
And John, you and I had this discussion the other day, with the hardening of the market, it's getting more difficult to get cyber liability insurance. And I think we're going to see, unfortunately, more and more people not have it or have a harder time getting the coverage that they'd like to have in place. I think that the nature of the incident response effort changes dramatically when there's no insurance in place because of the costs that are associated with the ransomware attack. What have you seen with regard to incident response for those who are uninsured versus insured?
Usually a lot of false starts. They're not as practiced generally. The first responders aren't as rigorous in how they go about it. One of the major benefits of being inside the insurance ecosystem is that everybody you're dealing with has been through this hundreds of times, if not more often. And having that kind of experience makes a huge difference in the overall results. So our clients that don't buy cyber insurance, they still have to deal with it. They just have to deal with it on their own without the guidance that they get from being within that ecosystem. They have their advisors, they have their lawyers, they have their historic forensic investigation firm, which may or may not be the best choice in the teeth of an attack. So there tend to be a lot of false starts and greater costs. They may not know how to negotiate a ransom demand.
Right. It's certainly not a good scene. I see them taking shortcuts. Sometimes, incidences are not even reported, which again could really get them in troubled waters legally and regulatory wise. Just very briefly, for any attorneys who are on this webinar, please don't forget the ethics. There are RPCs, and the ABA has two very important formal opinions with regard to encryption and how to respond to a breach should it occur that you really need to follow. As we mentioned earlier on, these cyber attacks are not just about data loss. They really are now affecting the safety of human life. In this water treatment plant attack, which I'm sure you all heard about, the attacker was able to gain access to the system remotely. Thank goodness for the treatment plant operator who actually saw his cursor being moved around the computer screen, opening software functions that control the water being treated in the system. This attacker was trying to boost the level of sodium hydroxide or lye, which really would have caused harm to the residents, including burns, severe pain, vomiting, and bleeding. So we had a good plant operator who was on top of things, and he was able to reverse this action. Since that time, as you know, we've also seen a major attack on the U.S. pipeline, Colonial Pipeline. That was a ransomware as a service attack involving DarkSide, who I understand is now shut down their operations. They really did get beat up there for a while. They claimed they didn't mean to attack a major pipeline or cause that much disruption. They were just trying to attack someone or something, but they certainly got the attention from the U.S. government and probably others that caused them to shut down. But don't worry, because they made $90 million in 9 months attacking about 40 organizations. So they certainly earned their money, except for what the U.S. government just took back from them. But again, look at the disruption that attack caused on the country and on individuals. This one really applies to the audience. I mean, it has to do with attackers impacting the food supply in our country. Would anyone like to comment upon this? Brian, Alex, John?
Well, this is one of these rich targets that you find, a large meat processing company. Part of the costs that the threat actor considers is, okay, if I attack JBS, and put them out of business and lock down their computers for a couple of weeks, how much are they going to lose? And that's and such a vital service that JBS provides. So this is one of the rich targets that we were talking about earlier.
And this goes to the point, Karen, that I don't expect the JBS has my personal information or yours or personal information of many individuals beyond its employees, but it's rich for other reasons. And that's because of the potential business interruption costs and go down the chain.
In addition to that, just to add on to the points that Brian and John brought on, is that Rebel, the group that hit JBS, love hitting high value targets. That's one of their top tactics, and that's how they make more money. They also are ransomware as a service, and they have splinter cells going throughout the Russian areas. And so we've seen Rebel on the darknet talking about this. They talked to actually one of these YouTube vloggers called Russian OSINT, and they've spoken to them multiple times and giving them this information like, we don't want small targets, we are trying to hit big targets. And with regards to this, they actually didn't mean to cause any damage to the US-based part of JBS, but in the end, they're like, yeah, we did it, why not? Because that's who they are. They want to hit those big targets. They want to make that money on them. Luckily, I think JBS did have backups they were able to restore from, and they brought in a really good cyber forensics firm to assist with monitoring their endpoints and making sure that there was nothing else in the environment lurking to cause more effect.
Yeah, so again, you see certainly a pattern with these attacks, and you see, a variety of consequences that apply. What I always find unfortunate is that the victim, could potentially suffer twice by going through the costs and expenses of an attack, by having that exposure, and then having third-party claims like class action lawsuits, regulatory enforcement action, and other types of claims filed against them later. Another good reason for having a cyber liability policy of insurance. If you don't have one already, it is a transfer of risk, and you certainly will sleep better at night. So we've heard all about how awful ransomware is and the attacks. We've seen the awareness of these attacks and their debilitating impact. looked at very closely by our U.S. government now, and we're going to get into what they're doing. But what our government does is separate and apart from what private organizations need to do. The government is not going to be your incident response team. This is something that you have to properly prepare for in order to mitigate your loss. So I think everyone on this call will agree that the first 72 hours after an incident are probably the most crucial in terms of mitigating your loss and exposure. Containing the intrusion before it reaches systems, or to stop the data breach from ever occurring, certainly is the number one reason why you want to take action within the first 72 hours. You see the other issues. Certainly placing a broker and carrier on notice is key. John and Brian, do you want to touch upon that briefly?
Sure. I mean, many policies now, they have a hotline 24/7. You call the hotline directly. They engage with you right away with an incident response specialist, and you are within their ecosystem. The potential downside of being within the insurance ecosystem is that you do not have unfettered right to choose your first responders. The good side about that is that working with your broker, you can negotiate with the carrier when you place the policy so that you can try to get your preferred breach coach, your preferred forensic firm involved as part of the process. And I can tell you from personal experience, it is the most important thing to have a breach coach like Karen, who knows her way around this process. There are increasingly complex issues with respect to attorney-client privilege, which Karen can address. And you really need a quarterback who knows how to comply with the legal requirements and to help you navigate this process, because it is increasingly legal and regulatory.
What I was going to say is, maybe some of the listeners were wondering, okay, so they have my crown jewels. What's the big deal? Okay, so they release them. Well, then you could be subject to fines. You could be subject to a lawsuit for failure to safeguard their information. You could, just all sorts of things can arise from that. And so you do have to react. You have to provide everyone's whose personal information was compromised. You have to provide them notice, and there's significant costs in providing them notice. There's significant costs. Sometimes you have to provide credit monitoring. Almost all of these categories of potential exposure is something that generally is covered under a policy of insurance, but it is costs that you probably don't think of initially when you think of the costs of something like this.
And that's right, Brian. When we say ransomware attacks, they blow up your insurance policy. They cut across all the different insuring clauses, incident response, potential lawsuits, regulatory, business interruption, the cost of the payment itself, and system and data recovery are just a few of the costs you'll incur. They cut across everything. And if the attack affects your customers, you can get sued for E&O claims for failure of your products or services. You didn't make a delivery you were supposed to make. You didn't provide your customer with a product on a timely basis. So it cuts across all sorts of different liabilities.
And this is exactly why people have, and something that we've hit on multiple times, and that is to engage a breach counsel like Karen's to make sure that you understand where you need to report certain things to, let's say, employees, third parties, and victims of this. Even if the data wasn't exposed in that, and even if you pay for the decryptor, there may still be a possibility that you still need to notify these users that data may have been stolen.
Right. And a lot of times I will say to people when they first start to experience these attacks and they come our way, it's very upsetting, obviously, and you feel like you're in panic stage. But we certainly get you out of that quickly. We consider it crisis management. That's why you see, insurance carriers with 24/7, breach coaches with 24/7. We, not just us, but any breach coach, incident response, forensic firm, carrier, they are available around the clock to help get you through these types of attacks. So in terms, and I will say to people, you're not judged as much by the attack because everyone is going through them and no one is immune, but you will be judged by your incident response effort. So that's why it's important to, start quickly, get through the investigation under the attorney-client privilege, reach conclusions as to whether or not there's been unauthorized access of personally identifiable information that would require notification. And everything is documented, by the way, along the way with forensics and with legal, so that if later on someone wants to question your response effort and whether or not you did the right thing, you can respond in a way that is very defensible, so you can mitigate your loss and your exposure. So just simply, step one, don't panic and assemble that incident response team, hopefully through your carrier. It can be assigned. Sometimes people will put together their plan and team, certainly their plan, but their team in advance. They'll start working with the breach coach. They'll start working with the forensic firm, establishing a relationship. So they know how you operate. What business are you in? Who are your third-party vendors? Are there contracts out there that, you should be aware of that requires notification if there's an incident? So it's a holistic approach. So if something should happen, you are ready to get out of the gate pretty quickly, and you have a very responsive team in place who basically working with you and your IT will take things over and properly protect you. Obviously, containment and eradication, determining the scope of the compromise, has it spread laterally, and the strain of the ransomware. Again, way back in the beginning of this program, we talked about the different variants and strains. We want to know what that is.
And Karen, just one more thing on that. There are a lot of variants out there that put in different parts of their payload to know when computers are turned off. So another part of the incident response plan that I like to recommend is to not turn off devices, but instead of doing that, just disconnecting all of your networking cables. It's easier to put that back online than to have to figure out what kind of data was lost due to turning off that device because the ransomware disabled the device and bricked it.
Yeah, that's an excellent point, Alex. Thank you. Once you know the scope and the strain, and this is simplified, but we're trying just to inform you of what goes on next. You have basically 4 response options to the ransomware attack. The first is to restore files from backup, if you can, and as you know, based on what Alex said, and I think Brian, these threat actors are targeting backup too, because they knew that was certainly a loophole that you could take advantage of if there was an attack. Second, try to decrypt. There are some websites that will have decryption tools. Sometimes these threat actors have a conscience, and when they, back out of the threat landscape, they release their keys or certainly publish them. I don't know. I wouldn't put a lot of faith into finding a decryption key that's going to work that that you can rely upon. If you don't have a key, it would take a quadrillion years to try to decrypt. Your third response: do nothing and lose data. We have had cases after identifying the data that's at risk. It's benign data, meeting notes. It's not personally identifiable or other legally protected information. Sometimes you don't have to do anything if that information is not at risk. And certainly fourth, negotiate or pay. As I get that a bit more closely. This is an actual transcript from between a negotiator and a threat actor. It gives you a feel for what goes on. Alex, just if you would just mention a bit about the fact that if there's negotiation with the threat actor, it's certainly not from Arete or some of the other ransomware negotiators. You open a separate chat room. Do you want to just discuss that briefly?
Yeah, so with threat actors, we have a team that do the threat actor communications, and they are part of Arete, and what they do is only threat actor communications. They have about 10 years of experience within this, and I think a combined of almost 25 years throughout the 2 or 3 people there. And what they do is they are able to draft up communications to these threat actors in a way that make them potentially come down in number. We see a lot of this with some of the bigger variants, with them wanting to come down and basically work with you on. It's weird to say this, but it's basically a business to them. So imagine yourself negotiating with a potential venture or joint venture with another partner, and you're trying to get it to a place where you agree upon a certain amount. That's basically what we're doing here. And we want to get it to a place where, and this is where the insurance company comes in. This is where Karen comes in from counsel perspective, on being able to not only work with the carrier and counsel on an agreeable amount, but making sure that it's okay from the client, the victim's amount from their pockets. I mean, they'll be paying for this. So we really work from those 3 points on being able to communicate with these threat actors. And that's another thing with this is understanding that process. And certain times there are people who try to communicate, and we've seen that other IT people have spoken to the threat actors and had no idea what they were doing, and basically got themselves in a hole where they were going to pay the full amount just because either they wanted to pay $5 on a $100,000 initial demand, and or losing communication with the threat actor. And we're coming in after the fact where the threat actor has completely ghosted them at that point.
One thing I wanted to mention is, I mean, this is obviously a very important part of the process. And companies, forensic firms like Arete often have former members of law enforcement, the FBI, Department of Justice, as part of their teams to help in the negotiation process.
Yeah, so I mean, listen, Bob is the easy answer. Again, as I mentioned before, strategy changes throughout the entire incident response effort. Sometimes IT will tell us that they've located a machine that's encrypted that does have sensitive information on it, and they start to reconsider whether or not they want to pay. And the lesson learned there is know where your critical assets are, know where your key sensitive information is stored. It certainly speeds up the response effort, but it is a business decision in terms of whether or not you want to pay to recover your systems. Certainly, it used to be if you have backup, you're in a good spot, you'll never have to pay. Now they're attacking backup. So if it's the type of attack that exfiltrates information from your system, they have it, okay? You will probably get moved into notification, but what are we going to do about that exfiltrated data in the meantime? Some people will talk about wanting to pay in order to suppress the release of that data to a leak site. A lot of these ransomware groups have leak sites. They exfiltrate the data. They ask for a ransom. If you don't pay it, they threaten to leak it. Obviously, if you pay it, they'll probably leak it anyway, or they probably have already auctioned it off or sold it to someone else. So typically, no one recommends paying to suppress exfiltrated data. There are still some organizations who will do it. They think it adds to lowering their risk. But typically we don't recommend that you pay to suppress data. If it's the case of, are they going to exfiltrate and post this data on a leak site? What is it? Is it just PII? Or is it embarrassing information? We've had those cases too. Typically, we put a strategy in place to get as far as we can with the threat actor to stall, to roll out notification, knowing that ultimately, when we disengage, that information sooner or later will be posted to the leak site. I've had a couple of cases where it wasn't until 2 or 3 months after the case was completed with notification that information appeared. And I think, quite frankly, the client thought, why'd they go through the effort? And, the information hadn't been posted right away, and so it probably never will be. Well, they were wrong, because it was 2 or 3 months later. But listen, By then, we had conducted and finished our forensic investigation. We knew what we were dealing with. The notification letters had gone out. There'd been proper scripting internally and externally. So, you know, if that information was used for identity theft later on, they certainly had the proper protections in place. The only other thing we look for, sometimes we don't know if it's all the data that they've taken. We try to use the ransomware negotiator to get that intel from the threat actor. There's a way that they can do it. If they can, we know that there's the potential for a second data leak or data dump on the website. And should that happen, then again, we roll out notification in a defensible fashion. These are just some other things that you can think about in trying to decide whether or not you want to pay. It's certainly a joint decision made by the key stakeholders. Keep in mind the FBI, U.S. Conference of Mayors, they don't recommend. There was a new task force recently convened. They're doing great things. I don't think they're in favor of paying ransoms. The White House has just issued an open letter. The president has issued an executive order. So we are looking for ways to make sure that payment is not given to these threat actors, mostly because of national security. OFAC is something else that we all consider. I think Alex might have mentioned it earlier on. The Office of Financial Foreign Assets Control under the U.S. Treasury's Office. They issued an advisory on August 1, but some people thought it was a new advisory. It really wasn't. It had been in effect before that, but it was another reminder of people who engage with victims of ransomware attacks. And that would include, you know, cyber insurance, digital forensics, incident response, as well as financial service providers. If they're getting involved, they should be on the alert that if you pay a sanctioned group, and those lists change on a daily basis, you could be facing civil penalties for sanction violations based upon strict liability. Certainly there are situations, and not a lot, but certainly there are situations where some organization may have to pay a ransom to a sanctioned group. Otherwise, they will go out of business or face other type of tremendous harm. In those cases, sometimes you can work with the Department of Justice, you can work with OFAC, enter into a consent order, cooperate with law enforcement about that group, about the payment, so that they can gather their intel to put them in a stronger position to fight. So again, that strategy has to be rolled out. A lot of the ransomware groups, groups like Arete and other groups will conduct due diligence to see whether or not the group to be paid might be on the sanction list. The problem is sometimes you pay someone who's not on the sanction list, and then 6 months later they show up on the sanction list. So that's a gray area, and you know, something again that you need to discuss to see what your risk appetite is like. Anyone want to say anything else about that before we move on? This is just some legislation that's rolling out. New York obviously is being very proactive about whether or not ransom should be paid. I would imagine some other states are going to follow in those footsteps. This was the executive order that Biden released earlier after the Colonial Pipeline attack. It is meant to strengthen the supply chain in our country. It would be very interesting to see how this is followed and whether or not it's going to be effective. But certainly a good first move. There have been plenty of funds released to help support that initiative. The White House advisory came in the form of an open letter. If you don't have it, you could either get it on the internet. I would be happy to supply it. Anyone on this webinar would be happy to supply it to you. But it just goes over 5 best practices that organizations should try to follow to reduce their risk. These are not anything new. We had a webinar with CISA yesterday, the Cybersecurity Infrastructure Security Agency, who are overseeing a lot of these initiatives. And one of the questions I asked their chief counsel was, you know, we've seen breaches, we've seen enforcement actions, we've seen class action suits, we've seen frameworks like NIST and others. How do you get public and private organizations to follow these 5 best practices? And the short answer was basically the government is doing what they need to do to protect themselves, and this is your responsibility that you need to take on to protect yourself. So again, these are good checklists for you to take in, discuss with your key stakeholders, discuss with your incident response team, incorporate in your plan, and work with your IT on. Someone was talking there?
Well, Karen, to your point, this is the key area where cyber insurers have stepped in, and how, they are requiring a much greater level of security controls for an organization to be able to get insurance in the first place, and surely to get it at acceptable cost. There are now, which we'll talk about in a moment, best practices which are no longer nice to have, but are absolutely required as a threshold for you to be able to get insurance at all. They've been burned too badly to use their old methods of underwriting.
That's an excellent point, John. And when we get to best practices, which will be in 1 second, I would love for you to identify the best practices that get on your radar screen and the carrier's radar screen pretty quickly. You can't do everything at once, but what you can do may help you get that insurance. Just very briefly, with incident response, you've heard us talk about notification. Sometimes when they exfiltrate and they steal personally identifiable information, we need to notify. We work with vendors to get that done. You certainly you play a role in it. You see the draft letter before it goes out, and it's on your letterhead. And someone, usually president, CEO, will sign that letter, and we will send it out. The vendor will drop it in the mail. We get weekly event reports that tell us how many calls came into the call center, what the number of callers, coming in, how many people were activating credit monitoring. Typically, the good news is you were only charged by the number of people who activate, not by the number of people who get the notification letter. It's usually about $40 per person. The activation rate is about 5 to 8%. Unfortunately, we don't have a uniform federal law about data breach notification. So we are operating on 50 different notification laws. So when we conduct an investigation and look at the data that is at risk, we need to know the state of residency. Sometimes if there's a breach in New Jersey, doesn't mean everyone is a New Jersey resident. It could be people from around the country, and that is what drives our notification letter and our report to regulators.
Karen, I tell clients that cyber insurers want you to use a legal breach coach that has the state laws as their wallpaper. They don't want you to engage someone who has to look up the different laws, because it's really a patchwork. I know in my own state of Massachusetts, there are things you can say, there are things you must say, and there are things you cannot say in your notification to individuals. And it's really important to have, as your legal breach coach, someone who both knows the laws and has the regulators on their speed dial. Because
absolutely,
with the regulators from the get-go will determine the quality, the overall outcome of your engagement with them.
And some of these laws change quite frequently. I think there were 6 laws that were amended in 2020. So, not only do you need to know them, but you need to stay on top of the amendments to some of these laws and coordinate with some of the privacy laws that are rolling out as well. Contractual and regulatory requirements. Understand who you're doing business with. You should have an inventory of vendors, especially those that have connections to your network. But with regard to the contracts and third-party vendors, certainly make sure you have the right terms in them, the right to audit, the fact that they will cooperate if there is an incident and breach, the fact that they have certain security measures in place. You're going out of your way to have best practices in place, and then you do business with someone who doesn't, who exposes you in the event that they have an incident. So again, this is about transferring the risk and making sure that you have the proper contracts in place. John, I have a question for you on this slide. And obviously, you know, sometimes when we get into the case, the first question from the client will be, do we need to call the FBI? Or they will say to me, I've already called the FBI, which always concerns me because I don't know what they have reported. We don't call anything a breach until we're finished with our forensic investigation and there is a finding that there's been unauthorized access and exfiltration of personally identifiable information. So I don't like that word breach floating around because it triggers notification. So there is strategy involved with regard to getting law enforcement involved. But John, do some of these policies, and Brian, you may know this as well, do they require or do they make it mandatory for the insured to report an attack to law enforcement? And if so, when and who is responsible for knowing that? Is it the insured? I would imagine should understand their policy, certainly with regard to coverage, but especially as to that provision.
I'm familiar with one policy that does require contacting law enforcement, but what has changed in the last several months is that insurers will, as a matter of course, once a breach has been established and it's no longer an incident, they will bring in law enforcement for a variety of reasons, partly because law enforcement, as you know, can be very helpful in this situation. So we now expect, as a matter of course, once a breach has been established and the ransom is on the system, that law enforcement will be involved at the insurer's behest.
Brian?
In terms of, I agree with John, our policies actually don't require it, but we do expect that law enforcement may become involved, and we don't have a problem with that generally.
Lessons learned is step 7. This is a very important step of the incident response effort. You have to have an understanding of what worked, what didn't, and you need to cure those vulnerabilities that were exploited. John and Brian, again, my understanding is that especially during the underwriting period, you look for things like this. Is that right?
Yeah, I've had a lot of discussions with our underwriting group, and they do go through a checklist with people who have had previous incidents and make sure that anything that did go wrong from our insured's end won't go wrong again. So we do have enhanced underwriting guidelines in situations like that.
And something you said earlier, Karen, in cyber insurance, unlike many other types of insurance, it doesn't necessarily count against you if you have and report an incident. What they care about is how effectively you deal with an incident. And perversely, if you deal with a cyber incident effectively, it improves insurers' opinions of your organization. If you tell them you've never been compromised, they don't believe you. So they like it more if you say, we're on this all the time, we're monitoring situations, and here's how we've responded when we have had an incident. And if you do that without the carriers paying much or even any money, you are a great insured from their perspective.
And that's what you want to be, right? This is a very important slide. Everyone print this out, put it in your back pocket and discuss it and continue to discuss it. Is everyone there?
Yes.
Oh, okay. I just lost the screen, but I'll just keep talking. Make sure that you discuss this internally with your team. John just mentioned something. I'm sure Brian, again, will agree. Pick out 2 or 3, Brian and John, on which would really get the attention of underwriting and carriers for purposes of getting coverage or cyber liability policy. If you had to start with any one of these best practices, what would it be?
Well, I had a conversation with our national underwriting manager, and from his perspective, it's multi-factor authentication.
That used to be a nice to have, and now it's a must have for most carriers to consider quoting cyber insurance. There's one large carrier. The only thing it asks you is if you have multi-factor authentication for remote access, for privileged accounts, and for web-based email. The categories of things, just to kind of simplify it, are things you can do to keep attackers out of your network in the first place. That can include employee education, multi-factor authentication, patching, things that my colleagues can talk about. What do you do to detect intrusions once they occur? That can be endpoint detection and response. How do you limit or prevent lateral movement within your network? There's a range of tools that can do that. And how prepared are you to respond to and mitigate an attack? And there are various things you can do. And again, Brian, Karen, and Alex can talk about the specifics, but carriers are very focused on those broad